Welcome, welcome. Good afternoon from here in the Netherlands, in The Hague. My name is Aurélien Lorange, and together with my colleague, Mana Maria Urbanova, we'll be hosting this match on behalf of the Corax Foundation. We'll have two teams will be debating. Actually, this is the start of the competition for those teams. They got a topic to research on, and they'll be debating today about it. So it was 7 days ago that we gave that topic to both teams for them to prepare. We have a team within UK, we have a team within Botswana. Both universities are participating for the first time to the competition in this edition. So before, of course, we get to the debate itself, we have to remind that, of course, that match will count for the group phase. So it's the first match. There will be another one in that group as well during these days. And of course, now it is time to give the words to the participants themselves for introducing themselves. So, starting with University of Botswana, Miss Ruby Njonde. Can you introduce yourself?
Hello, my name is Ruby Njonde, and I'm representing the University of Botswana, and I'm very pleased to be at this debate.
Thank you, welcome. We have as well at the King's College London, Miss Aisha Amer. Welcome.
Hi, my name is Aisha Amar. I'm a second-year law student. I'm very excited to be here.
Thank you very much and welcome. We have as well in Botswana, Miss Kotia Chimologo.
Yes, sir. Sorry about that. I'm Kota Simologo, a fourth-year law student representing the University of Botswana.
So you are Kotia Chimologo, that's right?
Kota Simologo.
Ah, okay, sorry for the pronunciation. Okay. As well, second student on the side of King's College London, Nusha Nemadzade, sorry.
My name is Nusha Namadzade. I am second-year law student at King's College London. I'm very happy to be here and representing my school.
Thank you very much. So we have 3 members today, right, for the University of Botswana?
Hello, my name is Nell Ruth Sipilo. I'm a fourth-year law student at the University of Botswana.
Okay, welcome. Thank you very much. So we received a topic 7 days ago, which is for the public and for the judge. National laws should grant athletes a stronger property rights over their image and personal branding. Today you will be debating on this, but you don't know yet which position you will have, so that's why we'll now use a randomizer of positions for you to see, for all of us to see which position you will have. Remember that the team will be in favor, will be starting the match after the 5 minutes of preparation. So yeah, my colleague is showing you that there are 2 positions possible for each university, to be in favor and to be against. So for this debate, we see that the King's College London will be defending the position against the statement. As a consequence, the University of Botswana will be defending the position in favor of the statement. To clarify, it means that the University of Botswana will be starting the match and will be defending the position that national laws should grant athletes stronger property rights over their image and personal branding, while the King's College London team will be defending the position that national laws should not grant athletes stronger property rights over their image and personal branding. Now you'll have 5 minutes to review your preparation and position, and we'll hear the introduction on the side of the University of Botswana after the 5 minutes.
Thank you very much. So the time for preparation has now passed. We will proceed with the opening statement, starting with the debate team from University of Botswana. You have 4 minutes. Whenever you're ready, we'll start the timer.
Greetings to the judges and to my fellow competitors and the opposing team at King's College. And I'd like to start by affirming that national laws should grant athletes stronger property rights over their interests and personal branding. We believe that this is so because the definition and scope of the protection of property rights varies across different legislations in different countries, but many countries lack specific laws and statutes that effectively enforce and protect the property rights of athletes and sports players. And the underlying problem here is that a lot of sports players are exploited, especially those that are very young, those that are just entering the sports scene. They do not have the proper legal or negotiating power or the legal backup or legal enforcement to be able to properly negotiate their contracts, especially advertising contracts and contracts with a lot of these advertising companies. And so that is why we believe that they should be granted stronger property rights, because a lot of the time their companies and the team or the clubs that represent them use their and other branding companies use their images and use their names, their nicknames, and everything that falls under what an athlete is. And they use them in a way that is very exploitative and which can take away from their dignity and autonomy as athletes. And so we believe that it is very, very important for national laws to be able to enforce the protection of these rights. And many countries lack specific laws that can help to do this. For example, in South Africa, there's no specific law or statutes that allow for these property rights to be properly protected. And so a lot of young sports players, we see a lot of young people who just enter the sports arena, especially in track and field, such as Nigel Amos in Botswana and various other famous athletes. They enter the sports arena and their brand and their personal branding or their images are used by different universities, different schools, and different sports branding equipment. They use their name and they use their images without their consent. So they do not get any compensation for a lot of the exploitative use of their name and of their images. And this is in very ways very undermining of their autonomy and their dignity as sports players, but also even as sports has become even more famous, and sports historically have been very important in terms of sports players have been very important in terms of advertising and in terms of using their personal branding because they were the first celebrities. So they make a lot of money also from these advertising contracts and from these personal branding contracts and advertising for Nike and Adidas, and without being properly and effectively compensated for the use of their image or the use of their nickname or the use of their name. They're effectively exploited and taken advantage of by these other companies and by these brands for commercial use. And so they lack that effective means of making extra money or making other financial use of their own personal identity, which they've worked hard to be able to maintain and to be able to build. So we believe that it's very important that national laws enforce these property rights for these sports players and these athletes. A lot of the times, there are very many cases, even in Russia, for example, a scandal in 2003, when a Russian cross-country skier and Olympic champion Yulia Chepalova was used by Adidas, and the athlete claimed that her image was used by Adidas without her consent, and it was used to garner almost $2 million in terms of revenue for the Adidas branch in Russia at the time. And she got no compensation from the use of her image and from the use of her name in Adidas advertisements. And so we believe that despite a huge reaction in the media and various claims, she was finally able to win the case. And there have been many other examples, many other cases of, for example, Tiger Woods, where his brand was used without his consent, but it was used for an artwork. But he still claimed that it was an illegal use and exploitative use of his brand and his own image because he was unable to get any revenue from the use of his brand and his image, and copies of the artwork were sold in various news media outlets and to other people without his consent. And this can invariably and effectively undermine the dignity and the autonomy of these athletes, because if their image or their name is being used without their consent in advertisements or in illustrations or in other forms of reaching
Your
it to
time is
the...
up.
So we are very, very proud to propose this motion.
Thank you for your submission. Now turning to the position against King's College of London, you have 4 minutes whenever you're ready.
Thank you very much. We stand for the argument against further stronger national laws protecting the rights of athletes. Now, this is on certain bases. First of all, the relationship between individual athletes and the sporting parties with which they contract is an act of balancing the needs of the sport, the public, and the individual athletes, the achievement for which the current laws protecting the property rights of athletes to their image and personal branding, we believe, are sufficient. To understand this argument, we must first recognize the fact that on a national level, in many jurisdictions, there are no rights to image and personal branding, or the current privacy laws are not strong enough to protect the rights of athletes as individuals of general society. However, in being able to contract with federations, sporting organizations, teams, and other sports affiliated companies, these athletes gain certain IP rights that are associated with those companies through those contracts. Specifically, these are copyrights, trademark rights, rights to design, and rights to patent. Now, where we believe that this balancing act is sufficient and important is in the economic benefits that are generated through these contracts and the IP rights within which are protected. The economic benefits that sporting federations and companies and organizations accrue through the use of the image of athletes is not exploited against the athletes themselves. Instead, it is reinvested back into multiple stakeholders that benefit from the status quo. The three specific ones that we would like to focus on are technology, the athletes themselves, and the public. And the economic benefits that are accrued by these sporting federations, first and foremost, a lot of it is invested in sporting technology. This is both to increase the quality of the sport, allow for improved performance of the athlete, and other such benefits, one of which will be addressed down the line. Next is the athletes themselves. In being able to associate themselves and contract with high-level federations, organizations, and events, athletes have the opportunity to not only gain international property rights that they would not otherwise have, but they would do this in addition to gaining celebrity status and further reputation that they can then use down the line, and they can generate their own income through personal branding with. Next is the public. The public interest that is met through the current status quo is in two ways. First is through technological innovation. The sporting technology within which is protected with patent rights, the sporting technology that is invested in through these organizations is then sold on a mass scale to the public, which can then also benefit from the same higher quality sports level and athletic game playing that athletes also benefit from. However, in addition to that, sports as they currently stand have a significantly increasing social and cultural aspect to them. A lot of sports on an international level involve gathering a family, gathering of friends, and they have a qualitative benefit that has become so entrenched in the culture of many countries that it would be a significant harm to take this away from them. To increase international IP rights of athletes would infringe and would undermine the ability of all of this to take place. Why? Because if athletes were allowed greater IP rights, then they would be allowed greater autonomous and decision-making powers in how their images are used. And being allowed to decide how their images are used, they may, for example, be able to deny their use of their images for certain sponsorship agreements, certain contracts, and other such ways, or they may affiliate their images with competitive companies. All of this would undermine the contract and revenue stream of the sporting organizations and sporting federations and would significantly harm all stake parties involved. For this reason, we do not believe that we need stronger international property rights of athletes. Thank you very much.
Thank you for your submission. This concludes the opening statements, and we are now entering rebuttals. Starting with the position in favor, debate team of University of Botswana, you have 2 minutes.
Good day, everybody. First of all, we would like to recognize what side opposition has said before us. Now, they are telling us that there is an act of balancing interests, and that if we were to give athletes more rights than those that they already have, then it is going to create a shift and an imbalance in the rights that are already existing. Now, what we need to understand is that there should be a stakeholder analysis first and foremost. We need to look at who is putting in more and are they receiving adequate compensation for the effort that they are putting. We need to first and foremost recognize that athletes are the key players in this chain of events. Who are these athletes? Now, the athletes are the ones who are the brand ambassadors and they create their own name. Now, what happens is when they meet corporate bodies, they try to exploit the already existing image that an athlete has created for themselves in the name of advertising and in the name of promoting their businesses and to sell their products using the name and the face of the athletes. So this is to say that even if this is the price that is being paid, this is the potential price that is to be paid, if at all we give athletes higher rights than the ones that they already have, or stronger rights than they already have, then it is adequate to have such a situation happening because they are at the center and at the crux of this all. Now, another point that was raised by opposition was they had told us that they would not be having these intellectual property rights to begin with if it was not for the businesses that come into the picture and try to brand or try to sell using the athletes. Now, this is incorrect for the reason that, first of all, they find these athletes already having manifested in the athletic industry, having already made a name for themselves, given the prowess in the fields that they are in, given how they are stellar performers in the areas of expertise. They already have a name in place. So to say that they do not have these intellectual property rights to begin with is inaccurate and it is false. Now, with that said, ladies and gentlemen, I close our rebuttals as side government.
Thank you very much. For the first rebuttal in the position of against the debate statement, King's College of London, you have 2 minutes.
Thank you. Oh yeah, sorry, I'm muted on the wrong device. I will be starting my speech now. Am I still echoing? Okay. Is that better? Yeah, okay. Sorry about that. Starting in 3, 2, 1. I will be using my speech to talk about the specific stakeholder that the other side highlighted, which is the athletes, and how they would be better protected in this contractual relationship that they form with the federation. Now, the argument that we are making is that we should protect the integrity of sports federations, and we should do so by not providing athletes with stronger property rights. Now, why is the protection of federations really important, and how it will inevitably lead to the betterment for athletes? Federations exist for the sole purpose of bettering the sport. Therein, they perform functions that are integral for the well-being of athletes, but also the development of the sport, as Nush has already explained to us in detail. Now, the reason that federations are able to perform for the well-being of athletes better than the athletes are able to do so for themselves is because they have greater resources. Because they've been in the industry for so long, they're able to negotiate better contracts with third parties, and so they're able to gain better deals. They are able to have more resources where they are able to vet their contracts better. They are able to have more resources with bigger resources with which they network with bigger companies, and therefore they are able to gain more lucrative sponsorships that don't just exist for one athlete, but usually for the entire team as a whole. For this reason, it is much better for the athletes to work with the federation instead of working independently. It is simply the power of collective action over just letting each individual athlete negotiate their own contracts. And another reason for this is that federations are heavily integrated with sports within themselves. So the sport, considering that the sport cannot exist without the federation, it is much better for third parties to work with federations and therefore make contracts with them instead of just contracting with third parties as well. And in the case of litigation being needed, when athletes' rights are being violated, the federation is much able to protect them due to the higher amount of resources that they have. Thank you.
Thank you. For the second rebuttal, University of Botswana debate team, you have 2 minutes.
Thank you very much, Ms. Speaker. I would like to give our rebuttals on the case that has been so presented, being the matter of the athletes. We first like to make the point that without the sport, without the athlete, there is no sport. And as such, the athlete should be the primary consideration. It is a modern day slavery equivalent to say that we should put the interest of the sport as a whole over the athletes who work tirelessly on and off the pitch. From the field, they are expected to go and do shoots. They are expected to go and do media releases. And in return, they are compensated for about 3% of the revenue the brands create, which then in turn rebuts the example that they get better endorsements, they get better deals out of these placements. The reason why we put first and foremost emphasis on the need to have stronger intellectual property rights is so that the athletes themselves can be able to have in of themselves without the need to have brand labels generate income, because we've seen that these contracts that are these so-called good contracts that are negotiated on behalf of athletes are usually exploitative. A classical example being Vinicius Junior's recent departure from Puma. Another example being Novak Djokovic's recent departure from Reebok. He has decided to stand on his own because of the exploitative practices of these brands. So it makes no sense for us to say that we should forego the interest of the athletes whose image, likeness, and entire personality is being used in the sake of promoting the sport as a whole. Without the athlete, there is no sport. Now, we also wish to put an emphasis on the principle or a rebuttal on the place that with these intellectual property rights, without these intellectual property rights, they can generate income. We ask the question that the athlete is at the forefront, and everything that they do with making money is because they are seen by people, and without them being able to exploit their likeness, their image, and the sporting rights, TV rights, they cannot be able to generate any income.
Thank you. For the second rebuttal in the against position, debating of King's College London, you have 2 minutes.
Hey, can we just set up our timer? Yeah.
We would like to thank the opposing side for their wonderful lines of argument. Now we would like to focus on 2 main ones. First is the modern day exploitation of slavery. While it is understandable where the other side is coming from in regards to this argument, and all arguments have been taken into account, we must recognize the fact that what they are saying in regards to the athletes and the way that the athletes are being exploited can be addressed and mitigated and compensated in many other ways through law that do not require IP laws. Specifically, we can have stronger unionization, stronger protection of certain rights through contract, including stronger rights to privacy, stronger rights to freedom of expression, and stronger rights to publicity, all of which can be done without requiring further decision-making power and IP rights of individual athletes over their own personal images once in contract. As well, we would like to also focus on, once more, on the fact that in doing so, we will maintain both the federation and the sport and still address all of the ways that the other side is alleging that the athletes are harmed, which we recognize does exist, but we do not think IP is the only way of regarding. Now, one significant benefit in addressing all of the harms that athletes may see on an international scale through other means of contract is in recognition of a very specific party that is to benefit from better athlete protective rights in other means through contract and maintenance of the current sport, and that is disability. The current federations and the current sporting organizations are heavily involved in investment in disability and protection and creation of technology for furthering the ability of disabled individuals to participate in sports, to strengthen IP rights of athletes and recognize and meet the needs of athletes solely through IP rights and not other contractual means that can protect all parties involved would be to harm multiple stakeholders in the benefit of just one. Thank you.
Thank you for your submission. This now marks end of rebuttals and start of conclusion. Starting with the position in favor, University of Botswana's debate team, you have 2 minutes.
Please come again.
You have 2 minutes whenever you're ready for your conclusion.
We've made a point of the need for stronger property rights. And it is quite obvious that the other side agrees with us to say that there is more to be done than what is actually currently being done. We've identified intellectual property as the key for it, or a need for stronger intellectual property as the key for it, because it is the most effective and most efficient way of doing this. They have given us examples of unionization. They've given us examples of bolstering contract agreements. And we've already said that all these show that there is a need to actually address the core of it all, because the core of it all stems from the property rights themselves. If you allow somebody to hold the likeness, image, and the right to exploit the images of a person or the likeness of a person, it basically shows that you are allowing them to, in the modern day, own them in their entirety. And as a result, we've seen that these contractual remedies that have been offered, such as compensation, such as remuneration or repudiation of contracts, we've seen that it is a call to say something is wrong with the way we are currently doing things. And we cannot in any day or in any form in this house say that it is sufficient for us to remain with these without stronger property rights in place. We also find that it is more efficient that athletes are protected from exploitation. They are protected and given an opportunity to target markets that are bigger than them. And we wish for them to be able to independently and of their own volition, without having a need to consider the benefits for that bigger image or for that bigger company that is they are being contracted with, to be able to put themselves first. Because in these scenarios, in all these scenarios that the opposition team has put before us, it is not the athlete who's being placed front and center. And we say that the money is being brought in by the fans that are created by the athlete. As such, the athlete should be the primary consideration.
Thank you for your submission. For the concluding statement in the against position, debate team of King's College London, you have 2 minutes.
The case that we have put forward today is that the best way to protect athletes and sports industries today is through improved contractual rights and through unionization. We submit that even if you give athletes intellectual property rights, they will still need to contract with third parties and with federations to disseminate their image to the world. In cases where contracts are exploitative, it is not the fault that they don't have intellectual property rights. It is simply that their rights are not being protected within contract. Having intellectual property rights can still lead to exploitation within contracts. Therefore, what we have argued today is that contracts should be improved so that federations can better protect their athletes. An important facet for this is that this will bolster in sports industries altogether. And this is especially important given the importance of sports within societies. An important part of propagating an athlete's image is to allow them to connect with their fans. And an important way that athletes do this, as Nusha mentioned, is through media. In sports has been integrated into our society through media, through engaging with fans through newspapers, interviews, social media, etc. If we give athletes stronger property rights, it will make that use of media inaccessible, and it will make engaging with fans and engaging with industries much harder. It will make it much harder for federations to make deals to promote their athletes, and effectively hamper the athletes' abilities to market themselves. While the government side wants athletes to be better compensated, if you take away brand deals that are going to effectively earn them more money, you are going to hurt not only their ability to earn, but also their ability to engage with their fans and to improve their careers. Thank you.
Thank you for your submission. Now, this marks the end of the match, and you can relax. You will no longer be graded on this part. Given the time constraints, we'll do just a short feedback round in regards to your views on the match preparation. Maybe you heard the arguments from the other party that you were preparing for that side as well. So starting with the debate team of University of Botswana, Mr. Kortia Tsimologo, how did you find the match?
Well, I think the match was quite interesting in that there were a plethora of solutions raised and not just the clash on whether or not the issue is the issue wasn't moot, but there were more viable solutions raised. I wouldn't like to call them viable, though their efficiency is questionable to say. If we've seen a track record of such things happening, do we really think bolstering something that's not working would give us a better solution? So it's just flogging a dead horse. So I'd like to hand over to my teammates. I think they would like to also add on onto it.
Thank you. For the King's College London, Ms. Aisha Amer, how did you find the debate? Did you maybe hear also arguments that you were preparing for the other side?
Yes, I think I was a bit thrown off because the other side had very like persuasive arguments that were very like emotional in nature, because they were like talking about exploitation, and obviously when someone else is like, oh, your side is promoting exploitation, you don't want to be like, yes, like we support exploitation or something like that, because obviously we don't. So you have to like tiptoe around it and try to make all sides agree with each other, and that was a bit hard. It was also like hard to fit everything in 2 minutes, but I think it was a fun challenge, and it was fun to hear like what the other side thought, because there were definitely new things that we hadn't thought of before. So it was very interesting.
Thank you. From the University of Botswana, Ms. Ruby Nyonde, how did you find the match? Is this maybe a topic you also encountered in your studies?
Hello. I thought the match was very engaging. I thought that we were both able to really clash with each other and engage with each other in a very like academic way and a very intellectual way. So it was a very intellectual debate. It was a very engaging debate. It was a fun debate. And yeah, I think we enjoyed discussing this topic with each other. And it's an interesting topic that I didn't really think much about before the topic was given to us. So I thought it was very interesting to do the research that we did. The amount of research was a lot, but yeah, I feel like it's a very niche section of the law that was very interesting to learn more about. And no, it's not incorporated in our studies, but it was very interesting to learn more about it.
Thank you very much. From London, Ms. Nosha Nematse, how did you find the match? Is this maybe something that you have seen in your studies before? And is there any message you would like to share for the other team?
In truth, when we first saw this question, both my partner and I, we were a little bit taken aback by the question. This was not something that we had considered in the past, myself being from an international legal background. I have never come across question of sports in international law yet. So this was a very, very invigorating experience, a very learning experience. But both through the research that we did, we both recognized what a significant question this is for our current times. So it really, arguments made on the other side are not only valid, but some of them were some of the things that we were considering, but some, especially the modern day slavery, that took me aback, but it was a very, very strong point that was made. And I think it really opened our eyes. So I would like to thank the other team for a lot of the points that they made, and the passion that they put into their arguments, because what that did was, just like they reiterated, it recognized the fact that there is something that needs to be done even today. Now, whether or not IP rights are the way to do it, we don't know, but it allowed us the exposure to a certain current problem on international legal level, and it opened our eyes to how we may approach this.
Thank you very much. And joining us then from Gaborone, Ms. Neo Rossetilo, how did you find the match, and is there a message you would like to share with the other team?
The first message that I'd like to share is thank you for the nice interactive debate. It was quite eye-opening because, like, when I looked at the title, I was already biased as it was. But hearing the proposals and the arguments and the reasoning, it helped me be more open-minded to how maybe we don't really need to be strengthening national laws. But then at the same time, I was like, I'm torn towards my side even more, but I was able to appreciate their opinion and their point of view as well. So it was really very eye-opening and interesting, and I got to learn a lot of new things as well. So yeah, I look forward to more debates like this going forward.
Thank you very much. Thank you to both teams. Well done on your first match in the Hague Inter-University Law Debate Tournament in 2024. The judges will now have 2 business days to grade your match. Provide the scorecards. Once the organizing team validates the scores, both the results will be announced and you will be provided with your score sheets from the judges. So on that note, I wish you on behalf of the organization all the best for the rest of the week. Enjoy your weekends, and until the next time.
Many thanks. Thank you very much. See you next time. Thank you.
Thank you.
Thank you very
Very
much.
much.